The member. The Honourable Adam Searle.
Thank you, Mr Deputy President. I rise to make a contribution in the debate on this bill. Having thought about this issue over many years as an individual, a legal practitioner and now a Member of Parliament, I am of the view that the termination of pregnancy is something which should be safe, rare and legal. It is or should be a matter entirely and only for a woman and her medical practitioner. The choice is not whether to allow abortions or not. The choice is whether as a society we have legal or illegal abortion. We still have in our living memory the consequences for so many individuals of the criminalisation of abortion, the legal dangers individuals have been exposed to, the physical harms they have suffered, sometimes with fatal consequences. If we want a civilised society, and I believe most of us do, I believe very strongly that we need to ensure access to abortion is appropriately and fairly regulated and that services accessed are safe to women. The gateway should be left to women and their doctors only. To do otherwise will only result in more grief, danger and harm. My view has been informed by discussing the issues surrounding pregnancy termination with those who have been directly impacted, those who have made the decision to have a termination, and with those who have decided not to, with lawyers, with medical practitioners, ethicists, religious persons, both lay and clergy, as well as friends, relatives and those in the wider community. While views have not been unanimous and are deeply and passionately held, the balance has clearly been in favour of ensuring that women can access this medical service lawfully, safely and without interference from any person. On this issue, members of the Australian Labor Party and Parliament are permitted a conscience vote. We may vote according to our own views and beliefs rather than on the basis of any party policy or discipline. As a result, I will be voting for this bill despite its many imperfections. There are diverse views on the issue of principle involved, as well as on the detail of the legislation now before the House. I know there are deeply held convictions on all sides of this conversation, and I respect that. No one who knows me will be surprised to learn that I'm pro-choice. That's always been my position. Equally, no one should be surprised to learn that I think the bill we are considering is deeply flawed in a legal and technical sense. As I'll touch on briefly, access to this medical treatment rests upon an interpretation by the courts of aspects of the Crimes Act. On one view, at least prima facie, abortion is a crime, but there is a medical exemption based on a ruling by Judge Levine of the District Court. This bill removes those aspects of the Crimes Act, and therefore the case law...
Sorry, just before that lady leaves, she should not worry about having the baby here. That's all right. You shouldn't feel the need to go.
Thank you, Mr Deputy President. This bill removes those aspects of the Crimes Act, therefore the case law that has developed, which provides lawful access for women to abortion in this state, will also be removed by this bill. What will be left is a vacuum. One not filled by the bill, one that would be left to be filled by further developments in the law, one case at a time, by judges. Despite the enlightened approach of Judge Levine and other jurists, this is no guarantee that even current rights will be preserved. There must be a real risk that those rights will be jeopardised and perhaps even lost. Despite this, I'll be speaking and voting. I'm speaking and I will vote in favour of the bill because I think there are ways to address the problems I see with the bill's current content, and that is consistent with the approach I took some years ago to the euthanasia bill proposed by the Honourable Kate Fairman. This bill seeks to repeal offences under the Crimes Act relating to abortion, which I support. The bill also seeks to abolish any rule of the common law that creates an offence relating to abortion, which I also support. The bill provides that a failure to advise a patient of a conscientious objection or to refer the patient to another medical practitioner constitutes unsatisfactory professional conduct for the medical practitioner. I do not support this aspect of the bill, and it needs to be remedied. This aspect has been the subject of a lot of communication with me by medical practitioners and others. The bill also provides for exclusion zones around premises at which abortions are provided. I thoroughly support this, and if this bill is unsuccessful, I will of course be supporting the Honourable Penny Sharp's bill that affects that change. Originally, the criminalisation of carrying out abortions arose in the common law and migrated into the statutory common law here and in other jurisdictions. In New South Wales, the law is governed by sections 82 to 84 of the Crimes Act, as interpreted by R versus Wald, a 1971 ruling by Judge Levine, and of course the Court of Appeal decision in CES versus Super Clinics. Those sections of the Crimes Act prohibit unlawfully procuring a woman's miscarriage, and they carry maximum penalties of up to 10 years imprisonment. The Crimes Act, however, is silent on the word whether the word unlawfully implies that abortions are unlawful in all circumstances, or that abortions are unlawful in some circumstances but not in others, and the courts have clearly adopted this second approach. In the absence of Australian authority on the question of what constitutes an unlawful abortion, it was generally assumed that the legal position was reflected in the 1930s English case of R versus Bourne, where a leading gynaecologist and obstetric surgeon was acquitted by a jury after being charged with performing an unlawful abortion on a 14-year-old girl who became pregnant as a result of being raped. The judge, McNaughton, held that for the abortion to have been unlawful, the Crown would have had to have proved beyond reasonable doubt that the doctor did not act in good faith for the purpose only of preserving the life of the girl, and extended the situation to where the doctor believed, and I quote, on reasonable grounds with adequate knowledge, that the probable consequence of the pregnancy would be to make the woman a physical or mental wreck. Now, this was undefined, but there was little doubt the test required a very high level of danger. The Victorian case of R versus Davidson carried it a bit further, where Justice Menhennett confirmed that it all hinged on what the word unlawfully meant, and having particular regard to the deliberate and repeated use of the word unlawful and the nature of the offence, he determined that, and I quote, necessity is the appropriate principle to apply to determine whether a therapeutic abortion is lawful or unlawful, which led us to the New South Wales case of Wald, where Judge Levine held that if operations to terminate pregnancies were skillfully performed by qualified medical practitioners with a woman's consent, the operation would be lawful, provided only that the accused had an honest belief on reasonable grounds that what they did was necessary to preserve the woman involved from serious danger to their life or physical or mental health, which the continuance of the pregnancy would entail, not merely the normal dangers of pregnancy and childbirth, and that in the circumstances the danger of the operation was not out of proportion to the danger intended to be averted. The judge continued that it would be for the jury to decide whether there existed in the case of each woman any economic, social or medical ground or reason which in their view could constitute reasonable grounds upon which an accused could honestly and reasonably believe there would result a serious danger to her physical or mental health. The effect of this ruling was that economic and social factors could be considered when determining whether to lawfully terminate a pregnancy, and this decision was affirmed and indeed extended, I believe, in CS versus Super Clinics. Previous speakers have spoken about CS versus Super Clinics, which was essentially a wrongful birth case turning on a claim for damages brought by parents against a doctor following the birth of a child who would not have been born but for the negligence of doctors. And to determine whether it was possible to claim damages, the court had to rule whether any termination would have been lawful. And as I think the Honourable John Graham indicated, that each of the three judges applied the same test in Wald to the same set of facts but came to three quite different conclusions. And this shows the dangers of leaving this important area only to the judges. No criticism of those judges, but it just shows you the complexity of the issues involved and the dangers because of the different results you might get. However, the President of the Court of Appeal, Justice Kirby, held that a medical practitioner may take into account danger to the woman's health both during and after the pregnancy, and the judges did not disagree on that point. And I note the Honourable Trevor Khan spoke of the cases of Smart and Sood, where doctors were convicted for performing abortions outside the ruling of Levine in Wald. So termination of a pregnancy in New South Wales is lawful if the procedure is performed with the consent of the woman and by a registered medical practitioner. The medical practitioner procuring the termination has an honest belief based on reasonable grounds that the procedure is necessary to preserve the woman from serious danger to her life or physical or mental health. These grounds may be medical, economic or social, and in the circumstances the operation is not out of proportion to the danger to be avoided. Now, although not ideal, this has provided the ability for many women over the course of several decades, the ability to access abortions in a safe, secure and medically supervised manner. And any move to change the legal basis for the provision of abortions in New South Wales must at least be equal to the current protections. And I don't think the bill before the House is. I think the bill, if enacted in its present form, would create an uncertain legal foundation for the provision of abortions in New South Wales, because since Wald interprets the provisions of the Crimes Act by removing those aspects of the Crimes Act and not replacing them with provisions that stipulate the conditions of when abortions would be legal, and indeed making clear that the carrying out of abortions are in fact medical treatment, this would at least potentially result in there being a very uncertain legal foundation. And I don't think that's in anyone's interests. The bill should contain a provision that would specifically set out the conditions on which abortions would be legal in this state. The bill should contain provisions specifying that abortions must be carried out by a qualified medical practitioner. At least for surgical abortions, they should be carried out in a medical facility or in a place approved by the Health Minister. And I note, in my current form, my amendments don't address this issue, that don't currently distinguish between surgical and non-surgical abortions, and my understanding is that most of the abortions now carried out are not of surgical nature, and so if we do get to the committee stage, I would have to recalibrate that amendment. I think the bill in its current form would lead to a situation where the carrying out of an abortion, it would be unclear whether this would be deemed at law to be a medical procedure or a medical treatment, and which again raises the question of the law being developed by judges without the protection and guidance of existing case law. And I don't think that's a sensible move. I don't think that's in anyone's interests. Because I think we've got to make clear, because all this bill does is to decriminalise abortion. Takes it out of the Crimes Act, and I support that. But you create a vacuum which must be filled. There must be a definition of what abortion is. It must be a definition of when it can be carried out and by whom and in what circumstances. It must also make clear that carrying out abortions is providing medical treatment, because otherwise the ethical and legal protections that apply to medical practitioners and others who carry out abortions will not be engaged. Mere abolition of the criminal aspects of the law leaves a situation where it's not even a requirement that only a medical practitioner may carry out these procedures. That is certainly in no one's interest, because that raises the prospect of dangerous, harmful procedures engaged in. States and territories that have a position where abortion is decriminalised often leave the decision to have an abortion to the woman concerned, at least during the first trimester, have provisions ensuring that only registered medical practitioners or persons qualified may carry out these procedures. And, for example, Victoria provides that a registered medical practitioner may perform an abortion on demand up to 24 weeks thereafter. A registered medical practitioner may only carry out such a procedure if the medical practitioner reasonably believes the abortion is appropriate in all the circumstances and has consulted at least one other registered medical practitioner who also believes it is appropriate in all the circumstances. The ACT has abolished the offence of abortion, but has taken a different approach. They don't set the period of time in which it can be obtained on demand. It's left up to the medical practitioners, and I note medical practitioners, I haven't yet met one who performs these activities who would do so at a very late stage. So I think any law to decriminalise abortion should also contain not only a definition of what that is, but stipulate the conditions under which a woman may have an abortion, i.e. it's with the woman's consent only, that only registered medical practitioners may carry out abortions, and that abortions, or at least those carried out surgically, should be carried out in a place approved by the Minister for Health. It's also appropriate, I think, to contain clauses protecting medical practitioners to be able to refuse to perform abortions or to assist in carrying them out. There's a lot of concern by medical practitioners and others that this legislation, although not requiring them to do so, makes it unsatisfactory professional conduct if they have a conscientious objection and don't refer on a patient to someone who doesn't have that objection. I think any bill to decriminalise abortion should meet the needs of conscientious objectors by providing that no medical practitioner is under any duty to carry out or assist in carrying out an abortion and is entitled to refuse to assist in carrying out an abortion, and that failure to refer the patient elsewhere does not count as unsatisfactory professional conduct. Amendments should also provide that only registered medical practitioners can perform abortions, that they must take place, those that are surgical in nature must take place only in premises approved by the Health Minister, and no person is obliged to participate in carrying out or assist in carrying out an abortion, and a person is entitled to refuse to participate in carrying out an abortion. Importantly, amendments should also make clear that carrying out an abortion is or constitutes medical treatment, and that there is no common law rule that prevents that medical treatment being provided. It should also make clear that any person has the right to consent to and to refuse any medical treatment, including an abortion. These changes would make clear that it is covered by and regulated by the health practitioners' legislative regime, which is appropriate. Should this bill proceed beyond the second reading vote stage, I will move amendments in the committee stage that achieve those stated aims, because I think that those are necessary to make the legislation safe and workable and fair to all. However, and I note that there is some concern, of course, that this bill will not succeed at the second reading vote stage, and I take the point raised by the Honourable John Graham that this is the beginning of the conversation, I think, rather than the end. Where important social reforms like this are affected, a useful precursor is the development of the legislation through cross-party, non-partisan dialogue. That was absent from Ms Fairman's euthanasia bill, and that bill failed. Although I don't doubt Dr Faruqi's genuineness on this issue, that is not the way in which she proceeded. If this bill fails, I would certainly be interested in reaching out to other members across the chamber in developing a cross-party working group to carry on the conversation. Mr President, I thank honourable members for their consideration.
President.